Welcome to this rapid revision session of the EU law organized by Cambridge Business and Law Academy. I'm Barrister Saad Andalib. I'm a barrister of the Honorable Society of Lincoln's Inn and a full-time faculty member of Cambridge Business and Law Academy. The way I'm going to structure this rapid revision session is to start by suggesting you the importance chapters for the July 2020 exam, and then I will consider each of the chapter in turn. For the July 2020 exam, the important chapters according to me are free movement of goods, free movement of services and establishment, and the Charter of Fundamental Rights. It is highly likely that from the free movement of goods chapter and from the free movement of service and establishment chapter as well, you will find an essay question on the exam. And if we consider the last 5 years question, then it is highly likely that there will be an essay question from the Charter of Fundamental Rights chapter. As you have already been informed by the University of London, for this year July 2020 exam, you need to answer only 2 questions out of 8. It will be very wise to read those chapters which I have already suggested. Firstly, we will have a rapid revision of the chapter Free Movement of Goods. The free movement of goods between the member states is one of the 4 fundamental freedoms established by the Treaty of Rome. The original 1957 treaty spoke of creating a common market, but in the Single European Act of 1986, the term internal market was substituted. The term is defined in Article 26 of the TFEU as an area without internal frontiers. So the idea then is not simply that goods should be able to cross the borders between the member state without having to pay duties or face any other kind of obstacles, but that those very borders should cease to exist as far as the free movement of goods is concerned. So there should be a single market rather than a collection of national market, and the single market is an economic policy which pursued through legal measure. And the author of the original treaty recognized that there are 2 main means to establishing an integrated single market, and those are firstly the removal of existing barrier and secondly the harmonization of national rules. And this harmonization includes harmonizing the measures regulating technical standards and safety requirements as well. The second aspect, sometimes referred to as positive integration, because it requires the introduction of new EU-wide rules, standards to enable a particular product to be sold and used anywhere in the European Union. So if we now consider the definition of an internal market, as we have already suggested, you can find the definition from Article 26 of the TFEU. When considering the free movement of goods, it is very important to distinguish clearly between monetary barriers and non-monetary barriers. Because if it is a monetary barriers, then we should consider Article 30 of the TFEU or Article 110. And if it is a non-monetary barrier, then we should consider Article 34 to 36 of the TFEU. Firstly, we will consider the monetary barriers to trade, and the monetary barriers to trade are prohibited on Article 30 of the TFEU and as well on Article 110 of the TFEU, as we have already suggested. Article 30 prohibits custom duties on imports and exports and charges having equivalent effect between the member states. And according to the case of diamonds, a custom duty has 2 defining elements. Firstly, it is a pecuniary charge, and secondly, it is imposed on the good by reason of the fact that it crossed a frontier. So, for example, we can find a custom duty to be paid on the border and if we cross the border and then it is charged, then it is highly likely that it will not be considered as a custom duty. For considering the definition of a charges having equivalent effect, we should look at the case of Commission versus Italy, commonly referred as the statistical levy case. This case involved an Italian levy on imports and exports across its border. The levy was a very small sum, and it was used to pay for the gathering and publication of statistics on trade patterns. The Italian government in that case argued that the levy should not be considered as a custom duty or a charges having equivalent effect because the purpose of the levy was to give benefit to the traders by supplying the statistics on trade patterns. However, the European Court of Justice, which is now Court of Justice of the European Union, said that it is the effect, not the purpose of the levy that matters. And since extra fees and charges are likely to put imported goods at a disadvantage compared with domestically produced goods, the effect was equivalent to a custom duty. In that case, the definition of a charges having equivalent effect was as well provided, and you can see the definition from the slide shared. It must be noted that custom duties and charges having equivalent effect are prohibited, and there are no exception on the treaty which justifies any measure which can be termed as a custom duty or charges having equivalent effect. However, if we consider the case law, we will find two exceptions of Article 30. So, on two instances, charges can be imposed on traders on the border, and those are when it is proportionate payment for a genuine administrative service and when it is a charge for inspection required by EU law. Now we'll look at the first exception of Article 30, and for this you should bear in mind that for this exception to apply, there must be a specific benefit individually conferred on the importer or exporter. And if it is a benefit in the general interest of all exporter or to the public at large, it will not qualify according to the case of statistical levy. I can give you an example for this exception, which is that if importer of flowers waited in the border of Italy and then he need the freezing facilities on the border. If he decided to use the freezing facilities provided by the Italian government, then the Italian government can charge him money under this exception. But for the measure to be fall under this exception, it must be ensured by the Italian government that the charge is proportionate. And this like if flowers are stored on the fridge provided by the Italian government, then the Italian government should ensure that no more charge was imposed on the traders than what was the actual fee of the facilities. If we consider the second exception, which is charges for inspections mandatory under EU law, we should bear in mind that this exception applies when a member state charges a fee for an inspection where the inspection is required by EU directive and the directive doesn't specify who should pay for it. The charge is lawful under this exception if the member state is not going beyond what is obligatory under the directive, and the directive itself does not say who is to pay for the test. And finally, that the amount charged is based on the actual cost of carrying out the test, which is required by the EU law. These three requirements was provided in the case of Belgium versus Netherlands. I can give you an example for this exception to apply, and for this I will suggest that today in the world, we have a difficulties for the coronavirus, and if the EU provides a directive which says that all the goods should be examined on the border, or all the person should be all the person who are driving the lorries should be examined on the border. Then, and if the EU directive doesn't specify who should pay for the charge, then the member state can require the importers to pay for the service or the test which was provided in the border. And if it is specified by the directive that the member state should pay for the test or for the examination of the product, then the member state should pay for that, and they cannot rely on this exception. We'll now consider the another category of charges, monetary charges, which are prohibited, and those are discriminatory taxation. For considering this, firstly we should consider domestic taxes which apply to imported goods. Domestic taxes is defined in the case of Dankevid versus France as a general system of internal dues which applied systematically and in accordance with the same criteria to domestic product and imported product. Internal taxation is distinguished from custom duties and charges having equivalent effect. And now we'll look at the distinction between the custom duties and the internal tax. So for this, I will give you an example and suggestion to identify the prohibition which should fall under Article 30 and which should fall under Article 110 of the TFEU. If the charge is imposed on the importer on the border, then you should consider Article 30. And if the goods cross the border and then the charge is imposed on the importer when they try to sell the product, then you can consider Article 110 of the TFEU. Article 110 of the TFEU provides that discriminatory taxation which favors domestic production of or import from other member states are prohibited. The aim of the article is to achieve fiscal neutrality between domestic and imported goods. Article 110 has two paras, and those are Article 110 para 1 and Article 110 para 2. According to Article 110 para 1, it is prohibited to impose on the importer any tax which is in excess of that imposed directly or indirectly on similar domestic product. Article 110 para 2 provides the same prohibition for products which are not similar but are competitive products. So how we can define how we can determine which products are similar and which are competing. So for determining similar products, like it is very easy to identify the similar products, because if I can give you for example for that, if Italy imposed a tax rate of 5% for 1 kilo of banana, then it should be imposed on both domestic and imported bananas. So for Article 110 para 1, the member state must ensure that the rates of tax which were imposed are identical. And for Article 110 para 2, if the products are competing, then we should consider the case of Commission versus France, commonly referred as the tobacco case. In that case, it was said that the test which we should use for determining whether the products are competing is whether customers regard those products as fulfilling the same consumer need. And we should consider this case for understand what we should consider, which products are competing, and for this I will give you a brief discussion of that case. In that case, light tobacco and dark tobacco were considered as competing products. The reason behind this is that those products may generally meet the same consumer need. And if we consider another example, like between coffee and tea, then we will find that coffee and tea are generally are generally used for the meeting the same consumer need. And another example we should consider is the beer and wine. So if we consider beer and wine, I think not beer and wine, you should consider for that beer and for like any other kind of product similar to beer. I've forgotten that, and this thing is like lager or something like that. And if you consider this, you will find that those are required for fulfilling the same consumer need. So we should bear in mind that for similar product, the thing which the state must ensure, the EU state must ensure, is that the rates of tax should be identical or the same. And for competing product, according to the case of Commission versus Italy, which are referred as fulfilling the same consumer need, the rates of tax should be something like that, which don't give any kind of indirect protection to domestic goods. And for that purpose, you can consider one example which I will give now. And this example is that if we consider coffee and tea as competing products, and according to the case of Commission versus Belgium, then we can say that if Italy imposed 50 if it had 15% tax on coffee, and if there is no tea which were produced by Italy, then they can say that the government should ensure that for tea the rates of tax should be something like 10% or 12%, which is not like something which gives the good and indirect protection. We'll now consider Article 34 to 36, or in other words, the non-monetary barriers to trade. For this, you should bear in mind that member states may introduce a range of measures. They might be legal, administrative, or technical measures which have had the effect of deterring importers or making imported goods more expensive, and thus hindering intra-community trade. These might be classified sometimes as non-fiscal restriction and are covered by Article 34 to 36 of the treaty. Now we'll consider this in details. Article 34 states quite simply that quantitative restrictions on imports and all measures having equivalent effect shall be prohibited between the member states. You should bear in mind that Article 35 provides exactly the same prohibition in relation to exports. You should also note that a national measures which contravenes Article 34 is prima facie in breach of the treaty. However, there are exceptions to this rule. The first set of exceptions can be found on Article 36 of the TFEU. It provides specific circumstances in which a breach of Article 34 can be justified. And the second set of exceptions can be found from the judgment of the Court of Justice of the European Union. These are sometimes referred as the rule of reasons. Now we'll consider the definition of cure or quantitative restriction and amicure or measures having equivalent effect to quantitative restrictions. Cure is defined in the case of Gedo. In that case, the Court of Justice defined a cure in quite simple terms that any measures which amounts to a total or partial restraint of imports, exports or good in transit. So a quantitative restriction, it can be a quota or it can be a ban. For this, we need to consider another case, which is R versus Saad Andalib. In that case, a ban on pornographic material imported into the United Kingdom was imposed. It was held by the Court of Justice is that this kind of measure is clearly a quantitative restriction. Therefore, if you have a quota system which only allows a certain capacity of import or a certain volume of import, that is a quantitative restriction as well and is prohibited under Article 34 of the TFU, like the situation in R versus Saad Andalib where there was a total ban of the pornographic material. Now we'll consider the definition of the amicure, and amicure was defined in the case of Dasonville as all trading rules which are capable of hindering directly or indirectly, actually or potentially intra-community trade. This is sometimes known as the Dasonville formula. In that case, the Belgian law required a certificate of origin for all importer for a range of goods, including Scotch whisky. Mr. Dasonville was a trader in Belgium. He imported a consignment of Scotch whisky, but he imported it from France. The French seller was unable to provide Mr. Dasonville with a certificate of origin, which in fact could only be issued by the UK customs authorities. However, in that case, Mr. Dasonville went ahead with the transaction. He brought up the whiskey from France, but he used forged documents in order to be able to sell it into Belgium. The Belgian authorities discovered the forgery and Mr. Dasonville was prosecuted. Interestingly, Mr. Dasonville was using Article 36 as a direct effective provision in order to provide a defense for him in this criminal proceeding. In that case, his argument was that requirements such imposed in this case, the requirement of a origin marking, is clearly falls within the prohibition of Article 34, as it can be termed as a measures having equivalent effect to quantitative restriction, because it has the effect of actually hindering the trade. The Court of Justice in that case sided with this argument and provided the definition of amicure. If we consider now the Directive 70/50, we will find that there are two categories of amicure. Firstly, distinctly applicable amicure. It refers to measures that do not apply equally to domestic and imported products. And secondly, the indistinctly applicable measures and that do apply equally to domestic and imported products. We'll now see specific example of distinctly applicable amicures and indistinctly applicable amicures. Firstly, we will look at distinctly applicable amicures. And this type of amicures can be import license, and as they only imposed on the importer, it can be said that it has the effect of hindering at least potentially the intra-community trade. And this was concerned in the case of Commission versus UK re UHT milk. Another type of distinctly applicable MEQs are health inspections, which are required on the border, and this requirement clearly has the effect of hindering intra-community trade. For this kind of restriction, you can see the case of Sanjay scale. Another type of distinctly applicable measure are origin marking, and you can see the example of such a requirement in the case of Commission versus Ireland, commonly referred as the Irish souvenir case. In that case, it was said that origin marking requirement is clearly an MEQR. Another type of distinctly applicable MEQR are binational campaigns, which are considered by the Court of Justice in the case of Commission versus Ireland. However, not all type of binational campaigns will be considered as a MEQR. So we should consider the case of Apple and Peer Development Council. In that case, the European Court of Justice held that it was permissible for a campaign to promote a national product by referring to its particular qualities. For example, in that case, the advertisement of the apples were given by the Apple and Peer Development Council, and the advertisement was clearly based on the juiciness of the English apple and not the origin of the product itself. If we now turn on to indistinctly applicable measures or MEQR, we will find packing requirement, which are considered in the case of Walter Rao, Prandtl and Mars. I will demonstrate the case of Walter Rao. In that case, a Belgian law was introduced requiring margarine to be marked in cube-shaped packages. The purpose of the Belgian law was to enable Belgian shoppers to avoid confusion when choosing between butter and margarine. Thus, margarine had to be packed in a cube-shaped package. So in that case, what the Court of Justice said was that packing requirement like that clearly constitute a MEQR because it has the effect of actually hindering the trade. It is quite clear from that case if anyone wishes to import margarine in the Belgium, then they need to change the shape of the product, as not all the countries within the EU or European Union made margarine within like the shape which was prescribed by the Belgian law. Another type of indistinctly applicable MEQR are found in the heading of content and ingredient restrictions, and for this you can see the case of Commission versus Germany in the subject guide. In that case, the German government introduced rules banning the marketing of beer containing all additives and not just the additives for which there was concrete evidence of risk. The German rules were introduced by the German government in that case on the ground that the Germans drank a lot of beer and long-term effect of additives were not known. But in that case, it was clearly said that it should be qualified as a MEQR because if the importer wishes to import beers from outside Germany, then what should they do? They have to make it clear that those contents which are prohibited by the German law was not used on the beer, and for this it will clearly hinder intercommunity trade because not all the countries within the EU maintain this kind of restriction. Another type of indistinctly applicable MEQR excuse me, can be found on the case of on the heading of name restrictions, which are seen in the case of clinic laboratories. In that case, there was a name restriction which was imposed by the German authorities, and the Court of Justice said that it clearly falls within the Tassonville formula and become termed as an MEQR. So as we have already seen that the definition of MEQR is very wide, and any measures which has the effect of at least potentially hinder the trade will fall within that definition. So what the Court of Justice of the European Union should do for that was a raising concern for several years. So in the case of familiar press, and then in the case of cake and method, the Court of Justice accept the argument that a clear limit should be placed on the type of measure caught by Article 34. The judgment in cake creates two categories of trading rules, and those are product requirement and selling arrangement. In that case, it was said that product requirement affects in same way as the goods themselves, and selling arrangement don't require any change to the product itself, but it only restrict the way it is marketed. In that case, it was held that product requirement should be governed by the existing rules under Article 34 and should be prohibited, but selling arrangement fall outside the scope of Article 34 and are legal. So how you can identify on the question whether it's a product requirement or a selling arrangement? For this, you should bear in mind that a rule of thumb for distinguish between a product requirement and a selling arrangement is to ask whether, in order to comply with this rule, the importer has to make any physical alteration to the product. If your answer is yes, then it's a product requirement, and if not, it's a selling arrangement. However, it should be noted that not all selling arrangements fall outside the scope of Article 34, as you can see from the case of cake, where it was said that certain selling arrangements are not subjected to Article 34. So in the case of Schutwoven, it was said that selling arrangements are not subjected to Article 34, but it must be ensured that it affect in the same manner in law and in fact the marketing of domestic product and product from other member state. So if we consider the case of Schutwoven, we'll see that in that case, under the Austrian Code of Business and Industry 1994, traders such as bakers, butchers, and grocers were only permitted to sell on rounds from locality to locality or from door to door those goods which they also sold from a permanent establishment in the area or in an adjacent municipality. The Schutzwaffen, an association for the protection of the economic interest of the undertaking, brought an action against TK and the organization to restrain it from offering for sale on rounds groceries, which it did not sell in permanent establishment in that municipality or any adjacent one. The Court of Justice held that the legislation in question related to selling arrangement for certain goods, but that it did not affect in the same manner the marketing of domestic products with which the consumers are familiar with and that of product imported from other member states. As such, the rule did not apply equally in law and fact, but rather impede access to market of the member state of the importation for products from other member state. So in the government case, finally, the European Court of Justice has refined the cake test so that it is no longer a question simply asking whether a change to the product itself is required, but whether access to the market is made more difficult for imported product. It was as well affirmed in the case of Commission versus Italy, commonly referred as the Italian trailer, that this market access test was adopted whether a measure hinders access of products originating in other member state to the market of the member state. This was as well affirmed in the case of Michelson. We can consider this market access test by referring some cases like Hunemont Leclerc Siplec. In Huneman case, it was held that ban on advertisement of products in pharmacies amounted to a selling arrangement and fall outside the scope of Article 34. But in that case, what was the line of argument which was used by the importer is that the local consumers are familiar with the pharmaceutical product which are made by the concerned member state, but they are not familiar with the imported product. So how the imported product should be advertised if they want to promote the imported pharmaceutical products? And then in the case of Leclerc-Siplec, this view was criticized as such measures may pose a serious threat to the access to market like this, because without advertising, consumer would tend to go on buying the goods that they are familiar with or the local products. Later, in the Agostini case, it was accepted that ban on television advertisement engaged and breached Article 34 as it was the only effective form of promotion enabling De Agostini, a company, to penetrate into the Swedish market. And finally, in the case of Gourmet, it was held that ban on advertisement is liable to impede access to market for product from other member states more than for domestic produce, within which consumers are already familiar. Hence, such a prohibition would violate Article 34 of the TFEU. Now we will consider quickly the derogation provided by Article 36 of the TFEU. Article 36 provides 6 grounds on which MEQRs or QRs can be justified, and those are public morality, public policy, public security, protection of health and life of humans, animals or plants, protection of national treasures, protection of industrial and commercial property. However, it must be noted that for Article 36 to apply, firstly, it must be ensured that there was no EU harmonizing measure. So if the EU prescribed a standard or a measure for preserving an interest, the member state cannot impose their own measures for preserving the same interest, and it must be ensured before applying Article 36. Secondly, you should bear in mind that Article 36 applies both for distinctly applicable measures and as well for indistinctly applicable measures. So member states have to rely on any of the 6 grounds provided by Article 36 after ensuring that there was no EU harmonizing measure and after make it clear that it falls within the definition of MEQR or QR. The first exception is public morality, and there are very few cases where this ground has been pleaded. Article 36 conferred discretion on the member state to set their own standard in relation to public morality, provided that no lawful trade in such good was allowed within the member state. For example, you can see the case of Hen and Derby, where the prohibition was related to the ban on pornographic material into the United Kingdom. On that time, it was also prohibited in the United Kingdom to produce any kind of pornographic material or sell it for the purpose of business. So in that case, the measure was genuinely applied for the protection of British public morality. So it was permitted by the European Court of Justice. But later, in the case of Conigate, it was said that the same measure has a protectionist effect. The reason behind this is that on that time, some British company started to sell certain pornographic material within the regulated shops. and it was clearly had a protectionist effect on that time, because the pornographic material was allowed, because the British citizens are allowed to buy pornographic material on that time from the regulated or prescribed shops. Secondly, the public policy ground. There are also few cases where this ground has been pleaded. And it must be noted that public policy ground can never be used for economic reason, as was said in the case of Commission versus Italy. We can see an example of a case where this ground was successfully pleaded was in the case of R versus Thompson, where it was held that the UK's ban on the export of silver coins clearly fall within this derogation and can be justified, because the purpose of the ban was to stop the coins from being melted down or destroyed. The European Court of Justice accepted the UK's argument because the ban on export was necessary for the preservation of national mint, and it was one of the fundamental interests of society. Looking at the next ground of derogation, termed as public security, it is also used in a few cases. One case we can see the campus oil case, where it stated that maintenance of regular oil supply were fundamental to the existence of the state and a legitimate aspect of public security. In that case, the government prescribed that 35% of the petrols or in a petroleum station should be bought from the member state, and then the petrol station can import the petrol from another member state. The reason behind this is that they prescribed a fixed rate which was used for preserving the national oil supply, and it was clearly a necessary measure for the member state to preserve their national resources. Finally, we will consider the fourth ground of derogation provided under Article 36, and this is the protection of health and life of human, animals, and plants. It must be noted that there are many cases where this ground has been pleaded. The court will consider under this ground that whether the risk to health is genuine or a disguised restriction on trader, as was found in the Commission versus UK re-imports of poultry meat. What happened in that case was that the Commission is bringing an action against the United Kingdom in respect of an import ban on poultry meat, that is, chickens and turkeys. The United Kingdom had banned the import of poultry meat from all the member states with the exception of Denmark and Ireland. The United Kingdom used the argument that it will, if they permit the importation of the poultry meat from other member states, then the Newcastle virus will be affect the other poultry businesses, and it will as well will enter into the member state. The European Court of Justice examined this claim and rejected it. Excuse me. The evidence pointed to the fact that the UK had in fact been under considerable lobbying pressure from the domestic poultry producer to protect their interests, particularly in the month leading up to Christmas when high levels of poultry are consumed. The European Court of Justice in that case reached the conclusion that the United Kingdom was not primarily motivated by the desire to protect the health and life of humans, plants and animals. Instead, the court rejected the conclusion that the UK was primarily motivated by the commercial reasons. So what the court should take for the evidence? For this, you need to bear in mind that for justifying a measure under this ground of Article 36, the member state must take into account the evidence of any test already comply within the exporting state. For this, you can see the case of UHT milk. On that case, where the European Court of Justice said that as the product was all the products were already examined and tested in the member state, then the host state should not require another test which generally serves the same thing and which generally examine the same quality. So what is the court's duty for under this section, and what should the court consider for establishing whether the measure is a genuine or a disguised restriction? For this, we need to consider another principle which is sometimes referred as the precautionary principle. Before going to that, we will look at what should the court take into account as evidence of genuine health risk. Here, according to the case of additives in beer and according to the case of Commission versus Germany, the court should take into account the attitudes of other member states and of international health bodies when assessing whether the particular ingredient poses a real risk to health. We'll finally consider as I have said earlier, the precautionary principle. And what is the precautionary principle, and which we should consider under Article 36 derogation is more specifically for protection of life and health of human, plants, and animals. Where the available scientific evidence on the health impact of a particular substance is unclear, member state can rely on the precautionary principle. Under this principle, member state can decide what level of protection is appropriate subject to the proportionality rule, as was happened in the case of Sandoz. So if, take for example that the COVID-19 was discovered by one of the EU state, as it is completely clear from the WHO, and nowadays it's completely not clear from the scientific evidence that how the COVID-19 spreads by the poultry products. So poultry meat. So if a member state of within the European Union impose a restriction of all types of poultry meat by saying that it will spread that poultry meat will spread the COVID-19, then the before the WHO or any other international organization or any other acceptable community publish a research that say that the COVID-19 doesn't spread by the poultry meat, then through the poultry meat, then the member state can rely on this argument, and this is the precautionary principle. So we have already considered the four important derogations on which the member state can rely on to justify distinctly and as well indistinctly applicable MEQs. And for these exceptions, for the derogations to apply, we should as well, after relying on these grounds, we should as well make it clear that the measure must not constitute a means of arbitrary discrimination or disguised restriction on trade between the member states, as was seen in the case of Conigate, where the pornographic material was banned on the United Kingdom for the importers, but it was permitted within the United Kingdom to sell such kind of thing with the help of the regulated shop. So in that case there was a clearly a arbitrary discrimination, and the Court of Justice said that this type of discrimination cannot be justified. Finally, the measure must be proportionate, and for this we should consider two things. So the first, we should consider that what is the aim of a specific measure, and secondly, we should consider that what are the means of achieving this type of the member state's aim. And if the method or the restriction is the mm, less restrictive measure of achieving the same aims or the aims, then it can be said that it is proportionate. And if there are other methods capable of achieving the same objective which are less restrictive of intra-community trade, then this should not be used, according to the case of Repage-Per. So, if we consider a case and if we consider the argument for the proportionality, we can see the case of campus oil. In that case, what was the restriction was that that all the petroleum station within the member state should buy 35% of the reserve from the member state, and then only after buying 35% they can import petroleums. So in that case, the Court of Justice say that it is the most proportionate measure of which was required, or that it is the less restrictive measures or the least restrictive measures which can be taken by the member state for the protection of their oil or their oil industry, and for this it was clearly proportionate. If we now consider the rule of reason or the derogation which were provided by the Court of Justice, we'll see that beside Article 36 of the Treaty of the Functioning of the European Union, there are further grounds available for the member state on the basis of the case of Cassis. The Cassis de Dijon case developed the principle which had its roots in the Dasonville case towards indistinctly applicable measure. So you should bear in mind that the rule of reason or the in Court of Justice's developed derogation only can be used for indistinctly applicable measure. So there are some limitation for using the Cassis de Dijon principles or the rule of reasons for justifying a measure by the member state. Firstly, I will remind you about the case Cassis de Dijon and what happened in that case. So in that in that case, the German legislation laid down a minimum alcohol level of 25% per liter for certain spirits, including Cassis de Dijon. The German Cassis conformed to this level, but French Cassis did not, having an alcohol level of 15 to 20%. Therefore, it meant that the French Cassis de Dijon could not be sold lawfully in Germany because it did not have a sufficient alcohol content. So in that case, it was said that it is clearly an MEQR because it has the effect of actually hindering the intra-community trade. But the Court of Appeal in that said developed the justification of the indistinctly applicable measure prescribed by the member state, and we are now considering these justifications. So there are some limitations of the Cassis de Dijon principle, and we will consider this first. For the Cassis de Dijon principle to apply, the first limitation is that there must be no harmonizing national rule, as like we have considered this for Article 36 derogations. And the second limitation is that it only applies for indistinctly applicable measure, as I have already said this to you. And the third limitation is that the national rule must be necessary to secure one of the overriding public interests, which the court collectively calls the mandatory requirement. And the mandatory requirement listed by the Court of Justice in the case of Cassis de Dizon are effectiveness of fiscal supervision, the protection of health, the fairness of commercial transaction, and the defense of consumer protection. However, this list, which were developed by the Cassis de Dizon case, was later redeveloped by a number of cases, and further ground were added to this these justifications, and those are protection of environment, as was seen in the case of Commission versus Denmark, Danish bottles, the improvement of working condition, as was seen in the case of Webel, the protection of cultural and socio-cultural characteristics, as was say in the case as was discussed in the case of familiar press, the maintenance of press diversity seen in the case of familiar press, and also I've made an error for the third ground, the protection of culture and socio-cultural characteristics. You should consider the case of Synesthetic Essay versus Federation National des Cinemas. And for the fifth ground, the prevention of fraud, and another ground is the protection of fundamental right, as we can find this case on the case of Commission versus Austria. And the final limitation for the Cassis de Dizon derogations is the proportionality principle. And like the Article 36 derogation, if the member state want to justify an indistinctly applicable measure, then they must ensure that it was proportionate. And the same principle, as I have discussed earlier, should be used for the proportionality requirement. So we have already discussed, and we had a rapid revision of the free movement of goods chapter, and you can see on the slide here that I have made a small note on this chapter, and you can use this for the revision purposes, but I will suggest that you should read the subject guide, because the subject guide of for the module EU law is very enriched, and the case law was illustrated in the subject guide very well, so you should follow that part. But for the next 2 minutes, I will I will permit you to copy the slides shared. You can take photographs from the this video as well. The chapter free movement of service and establishment. You can see the learning outcome on the top of the page. Firstly, we will consider the distinction between the free movement of establishment and services. For this, we need to consider the case of Jevord versus Consiglio, which sets out the criteria for determining whether a person or company is establishment in another member state or is a provider of services in another member state. According to the case, the key difference is that establishment applies to an activity which is pursued on a stable and continuous basis in another member state, whereas services are temporary in nature. This case as well provided that whether the activity falls under establishment under Article 49 or service under Article 56 depends on four specific things, and those are the duration, regularity, periodicity, and the continuity of the claim. If the duration of the service is for a longer period and it is provided on a continuous basis and on a regular basis as well, then we will consider the prohibition contained in Article 49 and the work will be considered as an establishment rather than a service. Another key difference between service and establishment lies in the extent to which member states are allowed to impose their own rules on non-national. The court has held that in the case of establishment, the host state can require compliance with its own rules governing the activity concerned, subject to the principle of proportionality. On the other hand, the host state's rules should not be applied to the same extent to a person providing services on a temporary basis. Now we will move on to the next point. The heading is the scope of the service. If we look at the scope of the service provisions, we will find that the structure of the treaty provision is that Article 56 TFU contains the basic rule abolishing the restriction on the freedom to provide services. Article 57 defines service and 62 provides the treaty derogations. According to Article 57 of the TFU, two things characterize services, and these are they are temporary in nature and they are normally provided for remuneration. The second characteristic of remuneration removes things like gifts and unsolicited activity from the scope of treaty articles. However, it must be noted that for the exam purpose that it can be difficult to draw a clear line between service of economic nature and non-profit making ones. And in a series of cases, the court has held that it is not essential that the person who receives the service be the person who provides the remuneration. By applying this principle, excuse me, in Belgium versus Humble, a state school operating within the national educational system was held not to be providing services. On the other hand, a school in a private sector which is financed by the private means for profit is a provider of service under Article 56 of the TFEU. Now we'll look at immoral activities. And if the activity is immoral, then we should consider the case of Grogan. In that case, it was said that not even the morally questionable character of an activity removes it from the scope of free movement of services, provided that the service is lawful in the member state on which the service provider went to provide the services. By applying this principle, lotteries, despite their harmful nature, fail within the scope of Article 56 TFEU. We will now consider whether sports activity can be termed as a service. In Mecca Medina versus Commission, it was said that spouse clearly falls within the scope of service. And for this, we should as well consider the case of Bosman, where it was said that sports activity like football clearly falls within the definition provided on Article 57 of the TFEU and can be considered as services. We should as well look at the case of Delisi. In that case, mm, a Belgian judoka who participated judo at an international level challenges the Belgian federation-based system of selection of competitor for international competitions. He said that the selection rules clearly prevent him from taking part on international competitions and clearly falls within the restriction provided by Article 56 of the TFEU. In that case, though the Court of Justice said that the selection rule mm, don't in the selection rule doesn't breach the treaty provision regarding Article 56 of the TFEU, but it is clearly termed that sports activity falls within the scope of service. Now we'll look at the point of service and cross-border activity. And three broad categories of cross-border activities are covered by Article 56. And those are firstly cross-border activity with the service provider moving temporarily from state A to state B. Secondly, cross-border activity with the recipient of the service moving temporarily from state A to state B. And finally, cross-border activity with no person moving, instead the service itself moves. Firstly, we will consider the freedom to provide a service. So, the first cross-border activity. Article 56 clearly states that the freedom to provide a service and the scope of this freedom was demonstrated in Van Vis version. In Ciola case, which concerned a restriction imposed by the Australian authorities on the number of mooring on Lake Constance which could be held by boat owners resided in other member states. In that case, it was said that those boat owners are service providers. We should now consider the next point, the freedom to receive a service. The Court of Justice has extended the scope of Article 56 to include the freedom to receive services as well. For example, in Luigi and Cuban, two Italians traveling to another member state as tourists and for medical treatment were protected by Article 56 of the TFEU. We should as well consider under this heading the case of Cowan. What happened in this case was that a French law provided compensation for injuries to French national and resident who were victims of the crime. In that case, Mr. Cowan, who was on a visit to Paris, was robbed and injured and who claimed compensation under this law and refused on the basis of nationality. The Court of Justice said that this provision or this specific law of the French jurisdiction clearly breaches Article 56 of the TFEU. Now we will consider a number of cases for under the subheading B, which is cross-border activity with the recipient of the service moving temporarily from state A to B. And this concern healthcare. So for this type of cases, the question before the court is that whether the recipient of the service can claim reimbursement from the social security after receiving healthcare treatment from another member state within the European Union. In this regard, in Cole versus Union, the European Court of Justice held that the requirement for prior authorization as a prerequisite for reimbursement was contrary to Article 56 of the TFEU. However, such a requirement could be justified if there was a risk of seriously undermining the financial balance of the social security system and if it was proportionate. For this, we should bear in mind that if the medical expenses for which was incurred by receiving treatment from another member state is too high, then the member state can rely on this ground because definitely it will then seriously undermine the financial balance of the social security system. However, the member state can refuse to reimburse the recipient of the medical service if two requirements are satisfied according to the case of Smith versus Fairgums, and those are the treatment is normal in the professional circle concerned, which requires the treatment must be sufficiently tried and tested by the medical science, and secondly, the medical treatment was on that specific case necessary. Now we'll consider the third category of cross-border activity, which concern the services that move where the provider and recipient don't. For this, we can consider the case of Alpine Investment versus ministers. In that case, the Netherlands had introduced rules which prohibited cold calling for the sale of commodities on the future markets to non-professional investors. The restriction was imposed by the home state of establishment, but restricted the freedom to offer services in another member state. Despite this, the court held that Alpine could plead Article 56 against its own home state in this situation, stating that the right freely to provide services may be relied on by an undertaking as against the state in which it is established if the services are provided for person established in another member state. Now we'll consider the derogation of the freedom to free movement of services. And for this we need to consider two articles of the TFU, which are Article 51 and 52. Article 51 of the TFU allows member states to exclude activities connected even occasionally with the exercise of official services. So under this derogation, the member service provider cannot provide services which are governmental in nature. On the other hand, Article 52 of the TFU provides for derogation from the right of establishment and right to provide services on the same ground as for workers, namely public policy, public security, and public health. However, it must be noted that a national rule restricting the freedom to provide services must be compatible with the requirement of Article 56, and to do so, it must satisfy four-part test. And those are: firstly, the rule must be non-discriminatory; secondly, the rule must be justified by imperative requirement in the public interest; thirdly, the rule must be suitable for the attainment of the objective it pursues; and finally, the rule must not go beyond what is necessary to attain its objective. Now we'll consider the public interest ground, and before considering this, and for this, firstly, you have to establish that there is no harmonizing EU measure. And secondly, you need to establish one of the imperative requirement in the public interest to rely on. And then you have to establish that it was proportionate. For determining proportionality, two things must be considered. And the first thing is that what are the aims which were required for the member state and what are the means which were taken for achieving the aim. And if there were less restrictive means of achieving the same aim, then it will be considered as disproportionate. You can see the public interest grounds which were created the under various judgment of the Court of Justice of the European Union on the slide shared. So this is the end of this rapid revision session of the EU law. Thank you for your patience and best of luck for the forthcoming exams.